Good morning. Welcome to today's Federalist Society virtual event. Today is Monday, November 11th, and we are here to talk about working as a conservative on the other side of the V. I am Alita Cass, Vice President for Strategic Initiatives at the Federalist Society and Director of the Freedom of Thought Project, an initiative addressing new challenges and questions involving freedoms of thought, conscience, and expression. We are delighted to have Judge Paul Mady with us to moderate today's discussion. Judge Mady is well known to all of us within FedSoc and especially within the Freedom of Thought Project audience. He serves on the Third Circuit Court of Appeals, where he often has occasion to tackle the themes that are of interest to the freedom of thought community. As always, please note that all expressions of opinion offered today are those of the experts on today's program. We encourage our audience to submit questions to our panelists through the Q&A feature at the bottom of your screen. Judge Mady will review those questions. We're not going to turn the camera over, but he will draw on those questions as he moderates the conversation. So please do take advantage of that. Thanks very much for being with us today. Judge, the floor is yours.
Morning, everyone. Alita, thanks for the kind introduction, except for the part where you called us experts, but we are all still nonetheless pleased to be joining this discussion. I want to start by asking, what does the biography of a conservative lawyer look like? Take one example: a lawyer who attended a well-known school, clerked for a justice, and then joined Evans, Kitchell, and Jenkins, working on general civil matters, before partnering with Keith Reagan, and then Corson and Elliott, and finally, James Powers. At each, the lawyer took the matters that arrived, filed the complaints, and headed to trial. These are proud and accomplished firms that served their clients ably, and you've never heard of any of them. Or take another, who, like the first, attended a well-known school, clerked for a justice, and then tried cases against a hospital, a tobacco company, an airport, and an accounting firm, winning more than $1 billion for plaintiffs along the way in federal and state courts. You've never heard about those cases either. But for a combined 26 years, those were the practices of William Rehnquist and Neil Gorsuch. We are told reliably that conservatives don't do plaintiffs' work, that accomplishment in the law does not associate with those on the left side of the caption, that using your time and your talent to bring rather than defend cases or controversies, well, it's inconsistent with conservative goals, that no serious conservative chooses anything other than a law firm ranked by some for-profit organization as leading and global and giant. Of course, we are also told reliably any number of off-base and poorly reasoned and generally ridiculous things about conservative lawyers, usually by the law schools that are busy hacking off their students to these same global legal corporations, whose commitments to liberal causes in time and treasure is beyond measure. Since we know those expert voices of the academy lack credibility on most subjects, well, then why have conservative lawyers and legions of law students decided to take their advice on this one? Where, then, are the next chief and associate justices of the Supreme Court who made their mark rising for the plaintiff? We are fortunate to have the insights of 4 experienced voices to tackle this topic. Let me and I mean very briefly, introduce them. Davis Cooper is chairman and founding partner of Cooper Law Partners, a widely known and nationally recognized personal injury firm. Jay Edelson is founder and CEO of Edelson PC, one of the nation's leading plaintiffs' law firms handling matters from consumer privacy to environmental liability. Noah Hines is an associate at the plaintiffs' firm Keller Postman, where he works on a variety of trial and appellate matters in products liability and mass arbitration. And Libby Locke is partner and co-founder of Clare Locke, one of the country's most sought-after libel law firms. I do our speakers an enormous disservice with that very short introduction, so please take a moment after the program and read their fuller bios and the links to their extraordinary works in the bulletin for this event. So for today, We will start with each of our panelists sharing a bit about their path to the plaintiff's bar before we move to an open discussion. After what I know will be a lively exchange, we will turn to the audience questions. So please, as Alita said, post them at the bottom of the forum, and we'll make sure to get to them towards the end. So we're going to start our conversation with remarks by Davis. The floor is yours.
Thank you, Judge Mady. It's a pleasure to be here. Thanks to FedSoc for having me and putting this webinar on. I'll give you a little bit about my path to Cooper Law Partners, soon to be Cooper Masterman, which I'll get to. And then I'll tell you a little bit about what we do. So I began my legal career at my father's law firm, Cooper and Kirk in Washington, D.C. In 2014. I worked as an associate there until just recently, really. But in 2019, we had the opportunity to refer some cases, mass tort cases, to some well-known mass tort firms and lawyers. And that was sort of how I was exposed to the plaintiff side. That was the flavor of the plaintiff's bar that I was exposed to and was attracted to. I saw it as it was interesting to me coming from Cooper and Kirk to help individuals whose lives have been turned upside down. And so we continued to refer cases as the opportunities came until mid 2022, when I decided to wind down my time at Cooper and Kirk and start Cooper Law Partners. That was fun and interesting, and we've had a pretty interesting path up to this point in late 2024. The biggest milestone I would say that is relevant to folks who may be watching this webinar is that I effectively poached a up-and-coming superstar lawyer named Joe Masterman to come join me at the end of last year. He may be familiar to you in the audience, and we are currently working through and finalizing our name change from Cooper Law Partners to Cooper Masterman. So Cooper Law Partners, soon to be Cooper Masterman, we focus on mass torts and multi-district litigation primarily. That means we typically represent many individuals against a single defendant or a group of defendants who are, our clients are typically similarly situated. We work cooperatively with other mass tort plaintiff firms on leadership committees called plaintiff steering committees to try to bring these cases to resolution. We also do some appellate and briefing work for some plaintiff firms in our space and other areas. And then we also do some consulting for interested third parties to help them evaluate the merits of the cases and litigations that are in our universe. And so I think that gives you a decent picture about how I got here and what Cooper Law Partners, Cooper Masterman is doing.
Davis, thanks, and I appreciate that. Jay, let's turn to you. How did you arrive?
First, thank you. I'm really happy to be on the panel. I do have to make a quick disclaimer because I know the title is conservatives who are on the plaintiff side, and I don't quite fit that bill. I self-identify as a left-leaning independent thinker. So my firm definitely skews left, but we have plenty of conservatives at the firm, and as we'll get into later, we think that's a huge advantage. So I'm more here to talk about how conservatives can exist and thrive in plaintiff's work. In terms of my path, and I'll be real quick, I went to Michigan, so of course I was required to go to defense law. I did that. I was the person who was asking really annoying questions like, why are we actually doing this? And was told, can you please shut up and bill? And I was representing defendants in class actions, which I liked very much. I found it really interesting and creative. But I didn't like the incentives, and I didn't like the path that I was leading to. I didn't look at people who were 5 years older, 10 years older, 20 years older and say, I want to do that. I looked at the plaintiffs' attorneys and they were frankly having more fun. Also, I don't mean to come across different than I am, but you know, I looked at the plaintiffs side and I didn't think, oh my goodness, I can't do this work. I thought if they're succeeding, I certainly have a shot. So I started my own firm when I was about 3 or 4 years out of law school. We were 2 people at the time. We're now over 100 people. We also, like Davis said, we do what I view as high impact aggregate litigation. So class actions, mass actions, and we represent a lot of states in public client litigation. Davis and I differ on one big thing. He said that he works cooperatively with other people in the plaintiffs bar. We do not. We avoid the cases where we have to be on steering committees with 10, 15, 20 other firms. This is not a shot at Davis at all. It's good work, and I have no problem with it, but that is not what we like to do. We like to bring what we view as proprietary cases where we've developed them and where we can make our own decisions along with our clients, and where we don't have to be on the phone talking to 15 other lawyers once a week where everyone wants to shoot themselves in the head. That's it. Happy to turn this over.
Thanks, Jay. Noah, we'll turn to you next.
Sure. Thank you, Judge Mady. I'm at the firm Keller Postman, which I joined after about 2 years out of law school. So I clerked first and then worked at a defense side firm for a year doing sort of appellate work, law and briefing stuff. And I generally enjoyed what I did there, but I'd say I enjoy what I do now even more. And part of the pitch when I was joining the firm was that there's just an amazing variety of opportunity on the plaintiff side to make creative legal arguments. And it makes a huge sort of market difference to be a conservative just because there are so few conservatives on the plaintiff side, you know, now that Rehnquist and Gorsuch aren't here anymore. And part of the pitch to it is there's sort of an immense skepticism of sort of originalism and textualism as kind of ultimately results oriented on the plaintiff side, or even in the academy in general. And simply, if you're the type of person that takes a textualist argument seriously or an originalist argument seriously and says this can get to a result that can be good for your clients, for plaintiffs in general, rather than seeing it as, you know, inherently biased, is a huge advantage because people simply aren't making arguments like that. So what the firm does is it's sort of similar, I guess, in some ways to what Jay and Davis said is, you know, mass claims. So part of that is in multi-district litigation in federal court. A lot of times, in part inspired by the types of concerns Jay had, we tend to like to sue in state court because then it's sort of just us and you don't have to worry about leadership and can go faster and you don't have to deal with, you know, having 20 other firms to coordinate with. We also do some state representation. So we represent the state of Texas suing Google in an antitrust lawsuit. We represented the state of Texas against Meta. And that's just not the type of work that people who are, you know, left-leaning and donating to the opponents of the, you know, Texas Attorney General are likely to have a good chance pitching. And that can be true in a wide variety of areas where there are sort of public representations that are possible. It's going to be difficult if you're a strong, outspoken political opponent of, you know, half of the states, which a large number of plaintiff lawyers are. And then we do some class action cases, not a huge number. We have an antitrust case against Amazon and also against Live Nation and Ticketmaster. Those are class cases. And then another thing we do, which is somewhat distinctive, is mass arbitration. And that, again, was in part sort of just taking Supreme Court cases seriously and seeing where they lead. So Warren Postman basically started the practice with reading Concepcion and other cases and said, look, this would be really easy. You can bring these arbitrations and the other side pays for it. It's going to be just as good as a class action. And thought, okay, why not take that seriously? If you file 10,000 cases, wouldn't that be a positive result for clients? And it turns out it works reasonably well. I mean, it changes over time, but it can be a pretty good practice. And for an associate, certainly, I'm the only associate on the panel now, it's an amazing experience because you get to go to trial, you get to write briefs because you're not sort of tied to the billable hour. And for the type of person that wants to be able to have high leverage moments and do more substantive work, it can be a lot of fun to have sort of the results in what you do directly tied and nobody telling you to go build more.
Thanks, Noah. Libby, round us out.
Thank you, Judge Matei. My name is Libby Locke, and I am the founding partner of Clare Locke LLP, along with my law partner, Tom Clare, who also is my husband. We started the firm 10 years ago. I had perhaps a pretty traditional path. I started at NYU as an undergrad and then Georgetown University Law Center for my JD, and went and clerked after, and then went into big law, starting my career at Kirkland & Ellis, first as an associate and then working my way up to a partner there. Left 10 years ago to found Clare Locke LLP. While at Kirkland, like Noah, was on the defense side, and then had this practice at Kirkland, which was really more of a institutional practice for clients, existing clients of the firm. Kirkland was one of the first firms to take on a plaintiff side defamation case, and that's the area that Clare Locke LLP focuses on, is defamation claims adverse to the media. But the practice was stagnant at Kirkland, and Tom and I left 10 years ago to start this firm. We're now up to, we have 25 or 26 folks who work here at the firm. And our work really focuses on pre-publication counseling, engaging with clients on, if you're the target of a hostile press, how do you engage with reporters or the media outlets? Where there is false reporting, seeking post-publication retractions, and where, if necessary, in bet the company situations, bringing litigation to vindicate reputation and rights. We were the really leading voices starting 10 years ago, calling for New York Times versus Sullivan to be overturned. This was before Trump ran in 2016 and started the chant, open up the libel laws. We're really proud that we've had a major impact on that area of the law and how judges and how people think about libel laws in the United States. Tom and I are both conservative. I've been a member and part of the Federalist Society since law school. But our clients are not uniformly conservative. In fact, many are not. And I don't think our practice is necessarily falls along politically conservative liberal lines. We represent high net worth individuals, Fortune 100 companies, sports teams, celebrities, and even on the rare occasion, journalists who have been targeted themselves by the press, which is always one of my most favorite kinds of clients, because journalists working in their capacity for media outlets often don't believe in the fundamentals of libel law. But where the media these days tend to be more left-leaning than right-leaning, there's a lot more opportunity to bring claims. The media gives us more opportunities to bring claims. And having our own firm gives us a lot more freedom to take on conservative clients that other big firms would not. And so, for example, I've represented Sarah Palin, Governor Palin, in the past against the New York Times. And I secured a reversal in the Second Circuit Court of Appeals of the dismissal of her first case against the New York Times, securing a remand for that case to go back to trial. She just secured a second reversal that I was not a part of, but I also represented Project Veritas, both against the New York Times and against CNN. And a big shout out to the 11th Circuit Court of Appeals this just past week for reversing the dismissal of a Veritas defamation claim against CNN. So that is going back down to the district court as well in a really extensive decision written by Judge Branch and a fiery concurrence by former Chief Judge Carnes of the 11th Circuit. So that is the work that we do. Similar to what Noah said, we have associates who get early opportunities, depositions, stand up in court. With our firm being so small, there's not a lot of ability to hoard those excellent opportunities for the senior folks, nor do we want to be doing all of them. So it's a great practice for those who believe in media accountability. And I'll leave it there.
Excellent. Thank you, Libby. So let's start our discussion with philosophy. I suspect one of the issues that drives a lot of resistance to students entering this field of work is this repeated sense that plaintiff's work is frivolous, right? That it lacks merit, that it is not grounded in law and facts, it is opportunistic. We've heard about this particularly from conservative thinkers for many decades now. I welcome anyone, and maybe Jay, I'll start with you, just to kick us off here. How do you respond to that criticism, and how have you seen that type of concern play out in your work?
Yeah, so that was my big concern switching over to the plaintiff side, which is I was going into kind of a pond which just had so many issues from lawyers who put their own self-interest first to lawyers who frankly weren't terribly good at their job. To be honest, I think that is an issue in the plaintiff's bar, but it's a segment of the plaintiff's bar. I think that especially when you get into the more complex cases, the types of practices we're talking about now, it's exactly the opposite. In order to do this type of work and be successful, you've got to be good. And part of being good is bringing good cases, right? If we bring frivolous cases, the people who are bringing frivolous cases are usually looking for, they're just trying to extort companies and get, $50,000, $100,000 in fees. Otherwise, there's going to be bad press. The cases we're talking about, where we're suing over hundreds of millions of dollars or billions of dollars, it's not like that. Defendants are going to fight. So you end up having firms that are really geared up towards fighting. So what I would say is that in the type of really high impact litigation, you don't see the problems like that at all. And I'd also say it's true on the defense side too. If you go to kind of the lower levels of the defense side, I think that they're a mess as well. So I was concerned about that, but I don't think that should be a concern anymore, as long as you pick kind of the right firm and the right area of law.
Davis, how about you? I know you talked a little bit about having to work with the plaintiff's bar a bit broadly. How do you see your interactions with other firms, and what types of concerns have arisen in your practice so far regarding the suitability of the claims that are being brought?
Sure. Well, we haven't encountered, at least in our short history, we haven't encountered any sort of exposure or offers to participate in projects that we think don't have merit or are some sort of nuisance value type of claim. I will say, you know, I think the philosophies are different. Coming from the Cooper and Kirk background, when we were first exposed to this space, you know, we had some of those concerns too. The cases that we were involved in were just so atypical for us. Folks who were injured by hernia mesh. Right now, we represent children who we believed were poisoned by toxic heavy metals in their baby food. And you can just Google this and you will see that there have been many investigations about thousands of times the safe amount of lead in baby food because of the sourcing of some of the ingredients. And so when I hear this frivolous claim idea, I sort of push back on it pretty strongly. At least in our experience, I went from Cooper and Kirk, a firm sort of working on, very impactful litigation at the highest level, cases with national import, to representing families whose lives have been turned upside down by, brain damage that we think was caused by, ingredients and products that shouldn't have been there. And so when it is much different in the sense that I was working with large organizations, very sophisticated clients, and now I'm working for clients who are average people. But in many ways, the cases feel more important to me because these cases are everything to our clients. It's not just a pet project. It's not defending some sort of annoyance. It's not. It is the thing that has altered their life completely. And so I have not encountered anyone in the space who has come to us to talk to us about a way to sort of make a lot of money off of a claim that probably doesn't have merit. It's all about, have you seen this awful thing that has happened? What are we going to do for the folks who've been impacted by it? What's the litigation strategy to do the best job we can for our clients? And so I haven't encountered it personally, and I just think that it's a mindset that I had before I went on the plaintiff side and I was exposed to mass torts that was adjusted when you talk to the type of people that you represent in the space.
Right, and I would assume, like anything else, there are different levels of actors and different financial models and different incentives that people pursue, and so a lot of this may come back down to self-selection. Libby, you saw this as well from both sides. You got to understand the practice of law, including the immediacy of the impact you can have on the clients in the kinds of cases you bring. How did you see that experience play out in the different settings, and what do you commend about the kinds of about the kinds of interaction you have with your clients now at your own firm?
It's a great question, and I was nodding as Davis was speaking because we also deal with clients when their lives have been turned upside down. There are very few things that you leave on this earth when we depart, our children and our reputation. We are dealing with clients in oftentimes their worst moment, in their darkest hour, after they have been falsely accused of some misconduct, whatever that misconduct is, and it impacts them profoundly in their profession, in their personal lives. And I find that incredibly rewarding, coming from the defense side where, as a junior lawyer, you spend time reviewing documents on some big, massive case. And yes, you're doing work on behalf of a client the client believes is for a worthy cause, but it doesn't have the same mission or feel when you are helping defense against reputational attacks. And so it's, and going back to your original question about, we hear it a lot, the critics of the work that I do, talking about, frivolous defamation claims. We need more laws, we need more protections against these frivolous claims. I can tell you for my clients, yes, the laws are very challenging to bring these kinds of claims, but these are not frivolous in my clients' eyes, who have been targeted in their view quite unfairly. At least from an economic perspective, our claims are generally not, by and large, are not brought on contingency. It doesn't lend itself to that kind of work, because who is to say what a reputation is worth? It's not like a corporation, in many publicly traded corporation, where there's a stock price associated with an individual's reputation. Rather, it's worth what a jury says it's worth, if you can get there. I think the self-selection point is a good one, Judge Matei, where a lot of our clients are self-selecting. Is it economically worth bringing the claim given the cost that goes into it? And that's where, the litigation that we bring is often bet the company, or, bet the livelihood, if you will, for individuals. But it's very mission-oriented work for our clients, and after a client has been falsely accused.
No, you had a promising young career and you threw it all away. I'm curious about how you reached the moment in your prior practice where you said, I want to do something different here. Was it this sort of client contact that we've been talking about? Was it the opportunity to help folks who might be in need? Or was it just the chance to maybe take your own deposition from time to time? What was the moment for you that crystallized the need to consider this opportunity?
Yeah, I think it was probably two main things. One was, I would sort of write briefs, and, I remember it was a cert petition that I wrote, and I thought there were sort of two interesting questions. And then the second one just got completely cut, and was like, that one's a little too out there. There were, multiple layers of review on everything that you did. And, I was a first or second year associate at that point. So it's sort of expected to some degree, but it just seemed like anything that I did was going to get sort of rewritten and redone enough times that it wouldn't have sort of a large degree of impact. And that was not as appealing to me. But the second thing, and sort of just as important, was the idea of who you're going to work with. So I, got dinner with Warren Postman. I spoke with Ashley Keller on the phone, and they're just really fun to talk to, and have, sort of conservative and or contrarian ideas about the law and about politics. And it's sort of a small firm where you can bounce ideas around, and that sort of shows up in the legal practice too, and the types of arguments that you can make. It's sort of sky's the limit if you can think of it, and if it has a shot, you can put it in the brief, and it can be, the first time in the country that that's come up. And it really feels like the things that you're doing actually move the litigation forward. And it's, I think, just more enjoyable way to practice law.
Enjoyable practices, satisfied clients, cutting edge issues, and the ability to contribute to the law. This seems easy, and yet here we are, right? So what is it that you think is holding back conservative applicants? And probably as part of that, I would say, well, given that you all have your, hands on the door, so to speak, what do students need to do to signal their interest in this kind of work? And when? Is this something you can come to later in your career? Or, as we've seen sometimes on the defense side, do you need to begin signaling your interest perhaps from your first 1L semester? Open up to any of our.
I'm happy to go first. So for us, in terms of whether you, well, let me start with what the block is. I think I think a lot of the reason, I think conservatives are coming to plaintiffs' work later than liberals. Liberals kind of found plaintiffs' work about 10 years ago in law school, when they started coming up with all of these plaintiffs associations, which are terrific, but they're really made up of left-leaning people, which is fine. Part of the reason for that is if you actually look at the career services, they lump plaintiffs' work in with public interest. And what they mean by public interest is really left-leaning public interest. So I think that people who are more conservative leaning or more independent didn't quite understand what the opportunities were. In terms of when you want to go to plaintiff's law, so this is where I'm probably going to differ with the rest of the panel. I am not a big believer that big law is good at training. I think that you can always get lucky and find lawyers that are willing to invest in you. But in general, the model is you hire associates and some of them make it past third year and then even fewer make it to partner. So because of that, you've got less incentive to really invest in them. Now, going off what the judge said at the beginning, and I apologize for this, I'm going to cite vault rankings with the admission that they don't mean anything. The only reason I'm citing them is because they're helpful to me and my firm. But I do agree they're meaningless. So vault listed us as the #2 best mid-sized firm for quality of work and #3 best mid-sized firm for career outlook. And we do, obviously, since they're positive, endorse vault and believe in that 100%. The reason, though, is that, you know, when we take on even a summer associate, what we're thinking is, how do we get them to accelerate their career as quickly as possible? So we had a summer associate who was very into negotiation. That's something which matters a lot to the firm. I think I'm okay at it. He went to 10 mediations during his 1L and 2L summer, where he was an active participant. You know, we're all, you know, our firm, in my view, it's a firm of ideas. So we were bringing groundbreaking cases. When we're talking about how to structure a settlement, no one has structured one before. He is a smart guy. He would write on the board, here's how we should do it. After 10 mediations, he knew a lot more about how to settle complex class actions than partners on the defense side. And so you've seen his career grow. He's now a partner at the firm. But even as a second or third year, he just had a deep understanding of plaintiff's law. And I would suggest to the audience that is the main reason to go into plaintiff's work. The reason I did it was self-actualization. How do you become the best version of yourself as quickly as possible? And I think that you can get lucky at other firms. You can go to the government. I don't know a lot about that. But on the plaintiff side, at least in my experience, you can get there the most quickly.
I'll speak on this issue. Having I take a sort of a middle ground on you know, whether big law is good or not to go and get training at. I certainly got great training at Kirkland coming through. I don't think I would have been nearly knowledgeable enough to go and do this practice or had enough training to do this practice as a third year or you know, first or third year associate. I think the block is, I think it's credentialing. I don't think some of the conservative plaintiff side firms are able to compete on name recognition, such as a big, you know, as a Kirkland or a Latham and Watkins. And so I call it the mom and dad problem. You are interviewing for a summer position, or you're interviewing after your clerkship, and you get an offer from Latham and Watkins and you get an offer from Clare Locke. You know, you may be more excited about the work at Clare Locke, given what we do, and the money may be the same, but going home to mom and dad and explaining that I'm turning down an institution who gave me an offer that's been around for 100 years, has 2,000 lawyers, you know, in favor of a 25-person law firm, it's, you know, there's a lot more risk in that. And so I think the more traditional path is to go into big law. I think you can get good training and experience. I think you have to really seek it out and know and make it known that you want it. You can also go and have a really bad experience where you're stuck in a conference room, you know, or document review for years on end. We're doing privilege logs. And so I think it could be a mixed bag. You know, the timing as to when, I think perhaps, you know, 4 years ago, I would have said, go to big law first, get a couple of years, get some experience, and then come to us. Now we're looking at folks, you know, as summers, we're looking at folks as first years or right off of clerkships. You know, we've launched our own training program here now that we've got a little bit of time and experience under our belts in running a law firm. And you know, I like training junior lawyers to come along, stand up in court, how to take a deposition, how to argue a motion. That to me is that's the kind of help that we need pushing these cases forward, as well as, you know, e-discovery and negotiating meet and confers. That's the kind of blocking and tackling work, real lawyering work that we want our associates to learn and to handle.
And Davis, maybe you can tackle this question. When did the shift occur? Because there clearly was a time when conservatives didn't think that it was necessary for them for them to work in large practices. I would cite none other than the work of Chuck Cooper, that you could do meaningful work in a small setting. But at some point, this just became, as Libby said, the kind of counter-credentialing that was not going to be suitable to anyone who was looking to ascend in conservative law and frankly, you know, generally in the legal practice. Putting aside that is a misguided premise, I am curious if you have a thought as to why it is that conservatives sort of ceded this ground and decided to congregate only in large firms rather than taking the kind of traditionally and historically grounded steps that lawyers had always did, which was to form their own practices.
Sure. I mean, you know, I'm not a historian in this sense, but I have witnessed my father sort of avoid the temptation to grow the firm into something that's bigger and more unwieldy than it is. That was not my path, and so I can only speculate. You know, my dream was to join Cooper and Kirk and work in that small family environment that I grew up in. I mean, I interned there when I was 14 years old. But I do think that it comes. I think that there is a path and there are expectations, and there's just a lot of pressure coming from every angle to sort of the young superstar conservative student. It's peer group, it's the competition to get, you know, the right clerkship, and then, you know, leverage that experience into a quote successful position at one of the major law firms. It is sort of the pinnacle path of the young conservative law student, and you get to work on interesting things, and it's the mom and dad problem. I think is, you know, Libby's mom and dad problem is, I think, a very important consideration. It's just what's expected. It's how you measure success, and it's the type of person. It may just be that the type of person that is the successful, ambitious conservative student is striving to be the successful conservative, you know, young lawyer who ends up at the big firm. I also think that there's an element of risk that goes into starting your own firm or joining a smaller firm like mine. I mean, my partner is, I think, is sort of the exhibit A of the successful, young, hard-charging, ambitious, conservative law student who got all the right clerkships and ended up at Cooper and Kirk. But I think his just risk tolerance, from what I can sense, is different. I mean, he's more risk tolerant. He's a little bit more excited about making his own way, even if he has to start go in reverse in terms of sort of the prestige and the accolades and sort of the applause that he would get from staying on the path that he was on before he joined what is now Cooper Masterman.
Yeah, these 2 points, I think, really start to get us to the heart of the matter. I am always fascinated by the mom and pop problem, in part because of my own experience. When I chose to leave New Jersey and go to a Washington firm, well, my mom and pop and friends and relatives, they couldn't understand what on earth I was thinking. Why was I not going down the street to either hang up my own shingle or to work with that good old Mr. Smith, who has a nice, fine practice? I mean, they saw this sort of as the opposite of what it is that a lawyer should be aspiring to do. Why would you be seeking not to help people locally, but taking on more regional matters? And so I think at an early point, I began to question this idea of credentialing, because it's always relative to who. Who is it that you are trying to impress with these associations? But Davis also touches upon something that I think is really interesting, which is how much of this is risk aversion. How much of this is conservatives specifically losing their courage and needing to constantly seek permission from a hierarchy as to what they're going to do with their time and value. And so I'll ask either maybe Noah, if you want to grab that one. Do we still see courage in the young conservative bar, or has it all simply become a path that too few are brave enough to deviate from?
I think that's definitely part of it. I will say on the mom and pop issue probably depends on your what sort of your parents do, maybe. I mean, my parents have not heard of any single law firm. And none of their friends have either. So I always kind of laugh when people ask me, if I say I'm an attorney, they're like, oh, where do you work? I'm like, have you heard of any law firm? No matter what answer I give, it's always going to be, just sort of a blank stare in response. There's probably areas of the country where that's not true, but I think for a large number of people, it's more in your own mind than it is anyone else that's going to care. It's that the law student coming out of law school and going has a certain self-conception, and that's really what's driving it, rather than, I think, sort of what their parents are going to think or other people, because the other people probably just aren't going to care. I do think a lot of it is courage, although conservatives are willing to be courageous in sort of joining, government or nonprofit oftentimes. I think that this is maybe plaintiff side work is not perceived as sort of a courageous thing to try. It's sort of just seen as riskier without a sort of countervailing benefit. And that's, I would think, why people don't do it. Because, if you go into big law, how much money you're going to make for the next, 9 years. And if you want to start a family, you want to pay off law school loans, it's a very, attractive option. Whereas, at least if you're going into government or nonprofit work, you can say, well, I'm doing this for a cause that I believe in. If you're going to go work for plaintiffs, you're thinking, okay, I don't necessarily believe in this to the same degree as like a political cause. And, oftentimes there sort of isn't a lockstep situation where you know exactly how much money you're going to make. And it can be, usually people don't have too much to worry about as far as money after a few years at least, and you can do very well. But I think it is sort of a risk aversion combined with sort of there isn't a sort of a non-money thing that people feel like is worth being courageous for, because they don't really believe in the sort of plaintiff side cause as much as perhaps they could.
I want to pick up on that point regarding costs, because it is a fair concern for many, and one that I think any of our panelists can address. Law students are likely leaving their education with hundreds of thousands of dollars in debt due to what is now considered to be a rationally functioned marketplace for higher education systems that is able to charge these amounts, right? So why then shouldn't a student say, I hear you, and I am in fact driven to be client focused and mission oriented, and I want to associate with the best and the brightest? I agree that all 4 of your firms offer me that chance, but I'm broke, and there's no way I'm turning down 2 years to pay down, if not pay off, all of that debt. Why shouldn't I just be that rational economic actor that we've been hearing about since the 70s. Libby, you want to take that one?
Sure. I mean, well, the answer is easy. If it's economic, you can make as much, if not more, here than you can in big law. At our firm, we have a compensation structure that is slightly, it's different than big law. It's not lockstep for if you're first year, you make first year salary and then maybe get a bonus at the end of the year. And if you get a bonus, it's the same as everybody else's. Ours is very merit-based, and it's focused on not only hours, but contribution to the firm. And we have many associates who make and well beat what their peers are making in big law. So from an economic perspective, and I imagine my peers here on this panel will say the same thing. From an economic perspective, it should be identical. It shouldn't be or better to come here. I still think it's maybe it's my the lens through which I practice and I look at things. I blame the media a lot for some of this, you know, the proliferation of the vaults of, you know, above the law. I love David Latt. I don't ascribe any ill will to him, but you know, the rankings of law schools and the rankings of law firms, with law firm being the next step after law school, I think it created you know, a competitive nature. Here are the best law firms to go to. They all happen to be massive and defense oriented. And therefore that is the next step. And so it is less risk averse. And precisely because you don't know, lawsuits don't either understand the difference between law firm A and law firm B. And even I recall myself like going through EIW as a law student, really not having a full appreciation for what these firms did. And even like sitting through these rounds and rounds and rounds of interviews, coming out being like, I still have no idea what this firm does or what its culture is. And you get a lot of those talking points. And the only thing you have to go on are these rankings. So, so I think that there's a little bit of that going on here too. But from an economic perspective, I think you can do actually a lot better in plaintiff side work.
Judge, do you mind if I weigh in?
Absolutely, Jack.
First of all, I saw Ted Franks in the audience, and I just wanted to give a shout out to him. I'm so glad that he's doing well, and I'm sure we all are. So on the money thing, at least in my firm, we do a lot better than big law. I think first years make $225, which is probably about the same as big law. And then our bonuses, we have more of an investment banker style of compensation. So I think, don't quote me on this, but I think every one of our associates did better than they would have at big law, but a lot did way better. So, you know, we had a summer associate get a $300,000 bonus. We had, you know, associates in the first, second, third year of their career get $700,000 bonuses, $1 million bonuses. You know, it's the money is there, and you don't have to wait 10 or 15 years in order to do that. And one of the reasons that the money is there is because you can always spin off and start your own firm. So it's very hard in big law to be able to have leverage of I'm going to leave unless you've got clients, and that takes a long time. On the plaintiff side, if you're really good and you're entrepreneurial, you can just leave. You can go to another plaintiff firm or you can start your own firm. So because of that, it's a totally different relationship. We are trying to train people up, but we also want to keep people there. We also think it's fair if they help win a case and we get $75 million in fees, maybe they should do pretty well too, regardless of their year. So I do agree that the pay overall is less in terms of base pay, but I don't think at every firm. I mean, I'll bet it at all the firms here. You can do quite well.
Lockstep is kind of socialist anyways.
I want to, again, I'm just mindful that I've made all the wrong career choices going into public service. So Jay, thanks for reminding me of that. And I also want to echo Jay's warm welcome to Ted Frank. We were delighted to see you here today, Ted. And as always, our prayers remain with you to get you back in the fight as soon as possible. Libby, I want to go back to you for something you said. You mentioned EIW. I believe that's NYU speak for on-campus interviewing or one of those.
Early interview. Yep.
So what is it that how is it that you and others in this field can increase your prominence on the campuses to make sure that there is this competing voice? Because we know that this is sort of like the rush, sort of like joining a fraternity or sorority every year on campuses. Is there a way to become a meaningful part of that conversation?
Well, Judge Matei, now you're just calling me out for not going to EIW and all of these schools. We're small enough that it doesn't make a lot of sense for us to come to EIW because we hire, one or two a year, one or two folks a year, and but it's why I'm here today. No, I'm here for a lot of reasons, but we hire opportunistically, and we want people to send resumes and to consider us. I think the way we do well on campus and beyond is our wins, and the success that we've had. And that's just keeping our heads down and litigating cases on behalf of our clients. It's probably not the answer you were looking for or expecting, but like the 11th Circuit win in Veritas versus CNN last week was in the New York Post and made I'll give David Ladd another shout out. It made his litigation of the week last week. And so I think doing really well for our clients and doing very high-end work on the merits is what is increasing our, people's awareness of who we are and what we do.
I want to continue to encourage people to submit questions. We have been drawing on them during our conversation here, and so we'll continue to get to yours as you post them, so please do. One thing I want to pivot back to, and this also comes from the questions that have been posed online, is why do we think conservatives are still so attracted to the work of large corporate law firms, given their robust commitment to only one set of pro bono litigation? Every firm, as we know, has a pro bono department, and all of those matters are uniformly going to be on one side of the social cause. To raise your hand at most firms and say, I have an idea to service a client in need that doesn't fit in that lockstep is all but certain to meet a vocal no. So what gives? Why do we think then that there is still so much attraction to these larger law firms, mindful of that, even putting aside, since we've now dispersed the economic consideration, how is that still a question? Now, I'll turn that one to you.
Yeah, I think a big part of it is, compared to what? So if you go to the most prominent plaintiff side firms, it's not better on pro bono work that they're doing. And so, there's sort of a sliver of law firms that are more open to conservatives, but even on this panel, right, we still have Jay. And I'm not sure how much conservative pro bono they're doing over at Edelson. So it's not like there are a lot of places where people that are conservative can go to do genuinely conservative pro bono. It pretty much is just at, pretty niche, like strongly conservative places like, Consovoy or Cooper and Kirk that do that type of work. I mean, so because even Keller Postman, for example, we don't do like conservative pro bono stuff. We do conservative arguments in the course of our normal cases, but it would be kind of a pretty strong business risk to do like a voting case or something like that that's out of our wheelhouse, just because we have a lot of co-counsel relationships and we have a lot of clients, and it's just very risky to take on that sort of thing outside the scope of your normal work. And so I think the pro bono side, it's like it's fairly overdetermined that there are going to be very few people that do conservative pro bono work.
Jay, love to hear your thoughts.
Yeah, thank you. Yeah, I kind of disagree with that. So one of the really fun thing about doing plaintiff side work is you get to do what you want. And I don't view the world as kind of conservative versus liberal. And so I don't know what a conservative pro bono case is versus a liberal pro bono case. We certainly do pro bono cases on things that matter to us. We sued Columbia pro bono because of not the speech that protesters were engaged in, but what we viewed as violent action and shutting down the school. I don't mean to speak for Ted Frank, but he's in a different sphere, but same ecosystem. And he's doing work suing protesters who shut down big parts of I think it was San Francisco or one of the California cities. One of my first pro bono cases was representing Rod Blagojevich, the governor who was being criminally indicted, and we handled the civil litigation for him. And the issue that really mattered to me, the reason I did it was because it was a question about legislative immunity and whether that would apply to a governor. And that was a really fun case for me. It was something I believed in strongly. We lost in district court and we won the Seventh Circuit. Again, I don't know if that's conservative or liberal, but it was in the other category of fun versus not fun. And we're happy to do that.
Let's talk about nuts and bolts. At a defense side firm, most, at least during the formative years, up to maybe even a decade of your practice, you're probably never going to have to worry about clients. They're going to come in through the institution, you're going to service them, and if all goes well, you'll continue that until you're old and gray. So what do I do if I want to join you folks? Do I need to find clients? Do I need to bring clients? And how do you find the clients you represent? Davis, let's turn to you, and then I'm sure others will jump in.
Sure. Well, you don't need to bring clients in our world. We are, typically we represent lots and lots of people who have been injured by the same product, or who have some grievance against the same defendant, and there's an entire structure to find those people. And so once we've made it known that we're working on a project, or that we've joined leadership for an MDL, we find that there's lots of lawyers around the country who will refer us cases, and we will build sort of our docket of representing clients that way. So we're in a, I would say, sort of the seed stage, right? We are probably by far the most immature firm that's represented today. We're still looking for critical foundational pieces to add to our team. And so what we're looking for most is grit, hunger, folks we like, folks we can depend on to be leaders of the firm now and in the future. You do not have to bring a book of business to our firm. We're engaged in building the book right now. I will say, just as a comment and as a difference between my experience at Cooper and Kirk versus what it's like now at Cooper Masterman, is that dealing with hundreds, thousands of clients who are all individuals and whose case means more than anything else in the world to them at that moment, and during the entire time that you're representing them. It's a completely different environment, and it's much more demanding to service those clients, because they need extra attention, they need education, they need a lot of care, and so one of the things that has been exciting to us, sort of transitioning from the Cooper Kirk world to the Cooper Masterman world, is figuring out how to be sort of best in class at helping people, not just legally, like through our efforts as lawyers, but really as sort of counselors, as resources, we're dealing with people who are going through a very difficult thing. And so we say it often in our firm that, you know, we actually have sort of the legal side, you know, taken care of. We're very, very confident that we are good lawyers and that we'll be able to, you know, write an effective, you know, Daubert brief or whatever. The question is how do we surpass the other firms in the space in terms of just client care? And we view our competitors in that regard as like the neighborhood doctor who will text you before and after your appointment, Amazon, who will answer the call within 2 seconds and tell you everything you need to know and make sure you leave that call, you know, satisfied. That's sort of been the sort of like a philosophical change in the way that we sort of do business and do law. So I hope that sort of answers your question, but yeah, to work at our firm at least, we don't expect you to bring in more, you know, babies who you think have been poisoned by baby food. We're looking for someone who cares about the babies who've been poisoned by baby food and who wants to build a practice that's going to serve people, of course, legally, but you know, emotionally as well.
How about at Clara Locke, Libby? What's the process of developing clients and how do young attorneys get involved with that?
Yeah, so definitely don't need a book of business to come here. In fact, would prefer that you don't have it because we barely have enough capacity to service what we have. But I agree with Davis. The thing that we look for most, especially in junior lawyers, do you have good judgment? And part of that judgment is whether you have empathy. And whether you can counsel clients in just real world situations when they are not necessarily thinking rationally, given the reputation has been under attack. And so, but balancing that with the legal standards and understanding what facts we need to develop in the cases. Truth is a defense to defamation. And sometimes you have to have really difficult conversations with clients about the alleged misconduct that has been put out there, and getting into the weeds and getting into the facts and having those conversations with clients when they're not acting rationally and not thinking rationally and are very upset because their lives are crumbling around them. And so for us, like, don't need a book of business. How do you develop clients? It's being with them and having empathy in their darkest hour, and also counseling them through the law and the legal standards so they understand that, after the press has written the article, there is not an easy fix to get things back on track. And it can be a long process to do so. And it can be an expensive process, and counseling them through that, what their options are, oftentimes involving many different disciplines to do that, not just legal, but also press, PR. And so that's, developing those client relationships. They kind of happen naturally in those crisis moments. And then it's, and that's how we end up getting the client work we do, is really through word of mouth. And, I had this in my crisis, I had Clara Locke help me, and, you should too.
No, is this something that was on your mind, when you were a young associate at a larger firm? Did you think about client development? Was it something wondered, how am I ever going to do that? And if so, how have those experiences shaped what you've done now at Keller Postman?
Yeah, I mean, I thought about that in terms of, okay, what practice area should I pick? If I stick with sort of appellate law, you're never going to be able to really develop clients because they're all one-off cases. If you go somewhere else, am I going to have to pick up golf, or how is this ever going to work? And in a way, the types of claims I do now, that type of concern is really low down the list, because I mean, basically the way you get a large number of clients for a case is there's sort of a theory of the case, in that there's going to be liability because of this, that, and the other thing, and you write a memo and decide to be meritorious, and then you go out and try to find people that have a valid claim fitting those criteria. And usually you do it with, advertisements of different sorts. And the difference between being good at that and being bad at that is, how much do you have to spend in, advertising to find meritorious claims, and how do you screen out claims that are very bad. And once you get closer to trial, where you're working with an individual, bellwether or something like that, you go to their house and you meet them. And of course, it's very important to be empathetic. But before that point, if you're just talking about, motion to dismiss, you have thousands of plaintiffs, you don't really individually find those people through word of mouth. It is much more like, a Fortune 500 company doing sort of advertisements and having a call center and things like that. And you have to have a high degree of operational excellence to do that well. But it is much more sort of wholesale rather than retail to do it well. And you have to use technology, because a big part of it is, can you do this in an economical way where you're not just sort of spending massive amounts of attorney time in order to sort of bring the claims, because that's not going to be helpful for anybody.
Jay, maybe your thoughts as well too, and if you could also touch upon a question that I think, an important one that comes from the comments. How do you make money doing this, right? Because my experience is law students know nothing about how to actually profit or even sustain themselves in the business of law, because law schools do not ever touch upon this subject. But when it comes to plaintiff side work, I think it's a mystery for even veteran members of the bar. What exactly is it that goes into your compensation structure, and how do you figure out what is the right kind of mix of cases to take?
Yeah, that's a great question. First, just touching on kind of what we look for. So I'm not the head of the empathy wing of the firm. What I am more focused on is the winning part. And I'm not suggesting the others on the panel aren't focused on winning. Everyone's very successful. But what we obviously want good people who care about the cases. But what we look for first is, are people, do they have a combination of hubris, where they think I can be one of the best lawyers in the country, and then humility of, I know to get there, I'm gonna have to swing and miss a lot, and I'm willing to make mistakes. We also want people who just have ideas, who have new ideas. We really believe in diversity of thought. And we love it when people come and during the interview say, okay, you had spoken on the Supreme Court. Did you want to win or lose? Because a loss would mean now the cases are back in state court. Isn't that good for you? Those types of discussions are what we're really looking for from law students and lawyers. In terms of the financial side of it, for mass actions and government work, it tends to be contingency, or almost exclusively contingency. That makes the cases a lot more interesting. We're working on very big cases. So if you do well for your clients, you're going to do very well. Class actions tend to be contingency. Sometimes courts will look at how much time you have and kind of cross-check against that. But still, there's way more upside. Now, the judge asked the toughest question, which is, okay, money comes in, how do you distribute it? And I kind of agree with Noah. I shouldn't say I definitely agree with Noah that, lockstep is not the best way to go. And, it's a difficult thing to do because, there is a big push for pay equity. Everyone should kind of end up in the same position. And we just don't agree with that. We think that you have to pay people based on their contributions and their value propositions, which means at the end of the day, it's we hear from their group leaders, we see their work, and we make a decision. And if since the numbers are pretty big, that it's a big kind of responsibility. But I think it works the best, and it definitely gets people who are very motivated, and the goal is to kind of keep them in the loop about how they're doing, and for them to have good expectations. I don't know if that answers your question.
It does, and sort of a related point. I wonder, when we talk about compensation in the law, most now understand that when we're talking about corporatized practices, partnership is now generally at a larger firm a title that appears on your website. It is not a partnership in the legal sense of the word, in the meaning you don't enjoy unrestricted divisional profit. In other words, you don't get equity. That's a whole nother system that is generally very opaque. I wonder if there is a similar challenge on the plaintiff side, in that it may be difficult for young lawyers ever to see themselves being in a position where they can share in the equity of the revenue. Or is the answer, and I think Jay suggested this earlier, but happened to have anyone pick up on it, is the answer you could just go start your own thing. If you get successful enough, you're going to be incentivized to go take your skills elsewhere. So I welcome anyone to answer, is that the sort of path to equity that might exist on the plaintiff side that's a little bit difficult to manage when your corporations are traded on, when your clients are traded on the stock exchanges? Jay, you want to take that one again?
Yeah, so it's hard to get equity in a plaintiff's firm. I would argue it matters less because the bonuses can be so high. There are years, to me, if you're really a good steward of your firm, you have to accept that you're the one making the decisions about how much risk to take, and that shouldn't fall on the other people. So if we have not a great year, that means maybe I get my salary, which is still way too much, but maybe I don't take extra money in, and I want to make sure that the associates and the partners still do well. The partners at the firm, they tend to do really, really well, and they beat big law, and they beat big law even with equity. So, one question is, what would be motivating someone to want to have equity? And it may be more control, although, our firm operates as a semi-benevolent dictatorship. So equity does not mean that you're going to have a ton of control. Except in your cases, we want everyone to have autonomy. It can be, ego too, except we think that we can achieve that in different ways, like putting people as lead in huge cases and giving them all the public credit. And then on the financial part, then the question is, does it actually matter if you're equity or non-equity, if you're getting paid kind of the same amount? It's not like you can sell a law firm easily. So I don't know. I mean, that's how our firm works, and we have not really lost people because they've said this, there's not enough upside.
I mean, on that, I don't think it's a coincidence that the other people on the panel have their names on the door. It's pretty common for plaintiff side firms for people to, split off at some point, or at least for that to be kind of a shadow of what could happen. And then maybe you get equity based on that. But it's certainly much more of a, one-off thing rather than a plan for everyone on a conveyor belt.
Libby, any thoughts on that?
Yeah, I agree with that. I mean, we don't have at Clairlock, we don't have a, in 6 years you're up for a non-equity position, in 10 years you're up for an equity position. Not to be uninteresting, but I agree completely with Jay. If you pay people well, equity people hear equity and they think it means, I think, something different than they understand it to be. Equity does not necessarily mean control, and it doesn't necessarily mean more money. It's just, in fact, it could be even more risk rather than less. We have a non-equity structure here at Clairlock. Our folks are paid exceedingly well, probably better than, it's hard to know. I mean, in big law, what non-equity partners are paid. I think there's a lot of disparity there. So I think you can come and have a ton of autonomy and a ton of experience, both the associate and and not equity ranks, and getting real in court and real experience and real client contact in a way that you don't in such a big law firm, and especially you don't dealing with, Fortune 100 companies where, in big law, the other, not so secret fact of the matter is that most cases don't go to trial anymore. And when you're talking about big law firms and being on the defense side, and you're being hired by, a major financial institution for a motion, a motion to dismiss hearing is coming up, there is 0.0% chance that a second or third year lawyer is going to be able to stand up in court and have any argument whatsoever, and exchange and back and forth with the judge, because those opportunities just come about so rarely. And so I think that that's another, not only the pay, not only autonomy over your cases. What does that autonomy mean? It means real opportunity to stand up in court and real opportunity to engage with clients in a way that that you just don't in a bigger firm.
So this, this model is, to my read, this model is very old, as I attempted to argue in the introduction. And what we're doing is simply rediscovering a way of practice that has always been part of our legal tradition, particularly on the conservative side. But it's still, its resurgence is still recent, and so we don't see a lot of firms doing this kind of work yet. Raise your hand if you want to offer a prediction of what this marketplace will look like in, say, 5 or 10 years. And while you're at it, raise your hand if you think part of the way that we'll see an explosion in plaintiff side advocacy from young-minded conservatives is to end the treadmill of elite credentialing. Are we willing to pursue a model that looks meaningfully different than the corporate law firms in terms of where you had to go to school, what kind of clerkships you had to have, and of course the associations that you put on your byline? Will we build differently while we're building better?
I'll sort of take that second piece. I think we are headed in that direction. I mean, thanks to folks like Libby and Noah and the Keller Postman firm. When we got exposed to mass torts, the partners at Cooper and Kirk, it was totally unfamiliar, really, to us. Just that the entire style, that the industry, the economics, and I think as more sort of leading conservatives, well-known conservatives, sort of step off the treadmill and do their own thing, open their own firm, embrace the plaintiff side of the V. I think that will lead to a more fertile environment for young lawyers to select that path, and it'll give some models. I mean, Ashley Keller is a great example, I think, of the type of lawyer who will make a meaningful impact on how young conservatives who are coming up in law school, who are president of their Federalist Society chapters, who are looking at where to clerk. They may look differently at where do I want to end up after I've taken a run at that path, or where does that path end with me. I don't think we're going to see a lot of change of young, ambitious conservative attorneys moving away from most of the treadmill, right? They're going to be on that treadmill. They're going to be trying to do the best they can in law school. They're going to be trying to get the best clerkships. I don't see that changing, but I do see what the end goal is for some of those students changing.
I agree with that. I think, especially with Trump winning the presidency, you're going to see a lot of conservatives, those that are in big law, are going to be exiting to the administration, leaving junior folks without sort of conservative mentors and conservative. I think there's going to be this exodus out of big law to go into the administration, and it's going to push the big law firms even farther to the left. And that I think is that's kind of a scary place to be for a young conservative who's trying to keep their head down and do well, but still maybe not feeling like these are their folks or these are their people with whom they want to continue their careers. So I worry about that. So I would encourage young lawyers to have that courage, to have that. I saw it in my experience in big law, and I know friends of mine saw it at other firms, but it was always the loudest minority speaking out where the firm actually made movement and engaged in a conversation and did something to address the concern. And so I don't generally see conservatives standing up and saying, hey, this isn't okay. I think we see it more now than we have historically. And so for those junior lawyers and mid-level lawyers in big law, I think it's important to have that courage and to make your voice known. And know that, if ultimately you don't affect change in these big institutions, that there are like-minded folks at other firms where you can go and where you can move to and be surrounded by people who share your values.
I want to pick up on, as we sort of reach the end of the conversation, I want to pick up something Libby just said, which I think we're all very well aware of, this idea that attorneys at certain firms are just keeping their heads down, which is a kind of remarkable self-assessment for us to ask, why is it that we would be encouraging anyone to go to a place where they have to feel as though their head must be kept down in order to simply continue doing the work for which they are being billed at an extraordinary rate, which sort of leads me to wonder this kind of, back to where we began with, like, is it doctrine all the way down here, right? Is the conservative legal movement now too indexed to corporate interests, and as a result, the law firms are pursuing a strategy that benefits corporate points of view with students that are aligned to accept as orthodoxy principles that benefit concentrated accretions of power? In other words, is this a doctrinal problem in the conservative legal movement that really didn't always exist, but has now become ascended? And if that's the case, well, how do we fix it? Noah, why don't you tackle that one?
Yeah, I don't think it's a doctrinal problem. I think maybe it's a problem of the types of the particular views of people who write about the doctrine or think about the doctrine. But I mean, there are lots of antitrust theories that you can come up with from a conservative perspective that work just fine. An example of one would be to say that the relevant antitrust statutes, if you look at their original public meaning, might be more restrictive than the doctrine currently is. And that's sort of a conservative argument that's available that some people have made. And that is not sort of a pro-corporate perspective. There's a lot of others in all sorts of areas of the law that people can make if they look at it. As far as keeping your head down, I mean, I think the problem of self-censorship is actually much more serious than the problem of being censored by others. And you really only need a critical mass of people who kind of can work through the awkward stare before it's more or less normalized, even though there's a little bit of pressure. Like the actual sort of coercive, you get fired for saying reasonable things, doesn't happen very much. And I think the downside of people keeping their heads down is that it's only kind of the provocative or extreme conservatives that say things, and then they give everyone else a bad name. So it's actually important for people that have sort of reasonable points of view to express them in a in a reasonable way, even if they're conservative.
Jay is the self-identified non-conservative lawyer of the group. Do you agree with Noah that it's not a doctrinal problem, or do you see doctrinal underpinnings to where it is that conservative students think they need to practice?
That's probably above my pay grade of, what I can say is that there's so much activity that could happen, that will happen over the next 5 to 10 years, that I think is especially aligned with conservatives. The convoy firm obviously had the Harvard Supreme Court case, and I speak to a lot of liberals or fellow non-conservatives, and their reaction suggests that there should be a lot of litigation because the view is, yeah, we don't like that decision, so whatever, we're going to keep doing this. And they don't seem to understand that it does apply to the employment context and all these other things too. I really don't understand the dividing line between conservatives and liberals as much as before. We do a lot of work against big tech. I think 15 years ago people would have said that makes us super liberal. The conservatives kind of claim that mantle for a lot of good reasons, and the Democrats been lagging behind. There's a lot of fun stuff there. So Judge, I think I'm ducking your question, and I apologize for that, but I'm probably just not the best person to answer it squarely.
I am used to attorneys ducking my questions, so consider it par for the course. Alita's arrival signals, unfortunately, the end of our conversation. So before I turn it over to her, I want to just thank the panelists for this really incredible exchange and the opportunity to share in this important discussion. Alita?
Thanks so much, Judge. And I want to share that on behalf of the Federalist Society, I want to thank panelists and our fantastic moderator for their time and expertise today. I also want to thank our audience for joining and participating and offering some great questions in the Q&A. We welcome listener feedback by email at info@fedsoc.org. Again, I hope to see many of you later this week at NLC, and I will note that several of our fantastic panelists here will be on very, very impressive showcase panels later this week. So tune in for that. Also want to flag for next Monday at 1 p.m. we will have a webinar on some new questions about the original public meaning of Section 230. So watch your inbox for that. Thanks everyone for joining us today. We are adjourned.